If a business owner has a piece of intellectual property that they're interested in having protected, at first instance, they're going to need to ask what type of intellectual property is it? Is it something that is an invention or other creative work that could require a patent? Is it a mark or symbol that could otherwise require trademark? And then finally, is it a creative work or work of authorship that is something that could actually be copyrighted? Ironically, with respect to copyrights may arise by law, but what you should know is that if you don't take the necessary steps to actually file and register your copyright with the U.S. Copyright Office, you run the risk of someone else out there with the competing work of authorship, or actually stealing your own work of authorship, actually claiming first rights and entitlement to use and exploitation of what you have developed yourself. So it's always incumbent upon you, whether some of these rights may arise by law or otherwise, to actually be the first to file with the respective copyright or patent and trademark office. With respect to patents, it's something very similar to the process for trademarks. Again, you're searching out there to determine whether or not anyone else has produced this invention, mark, or what have you, and you're trying to determine, after you've conducted this search, whether or not this is something that you can actually apply for with the U.S. Patent and Trademark Office to determine whether or not they will actually issue you respectively, either a patent or trademark for the covered good. So I guess in a nutshell, it's not enough to assume that just because you created something that you actually own the rights and entitlement to that. Someone who comes after you and copies your idea or creates something very similar could very well gain first rights to use and exploit the respective type of intellectual property, depending on whether or not you've taken the necessary steps to go and protect your rights by conducting a search, applying at the respective patent or copyright office, and then going ahead and registering your mark, your patent, what have you.